Okay, good morning again. We will start our second session in this Quaestio Facti workshop. We have Professor Rinat Kitai-Sangero, and she's Associate Professor at the Law School in Zefat Academic College, and her main research lines are criminal procedure, criminal law, law and literature, and therapeutic jurisprudence. And she has made important contributions in subjects as presumption of innocence, the burden of proof, preventing detentions, self-incrimination, among many others. And finally, the title of her presentation, it is The Use of Undercover State Agents as a Cause for False Convictions. Okay, it's your time now. Thank you for being here. And now, 4 minutes.
Muchas gracias. Hola a todos y muchas gracias por la invitación. Hablaré sobre los agentes encubiertos, cover agents, and now in English. Granting an undercover agent is planting an undercover agent in the detainee's cell so that the suspect is unaware of the rivalry and sees them as a friend and ally is a well-known and accepted investigative ploy. The role of the cover agent is to gain the trust of the suspect so that he will open a conversation with him and provide incriminating statements. In this presentation, I will describe the activity of cover agents, the arguments that support such activity, the distinction between passive and active cover agents, and eventually I will present the danger of extracting false confessions by cover agents. Usually, cover agents operate in detention environments. They are placed in the detainee's cell. The Inquisition in the Middle Ages already used this trick. In England, a ploy in the 19th century of sending a priest to the suspect cell who convinced him that full divine forgiveness is conditional upon confessing his sins to the authorities, motivated the cover agent ploy. However, the use of undercover agents sent to suspects outside of custody to befriend them in their natural surroundings is also a well-known investigative ploy. In such a case, the cover agents can pretend to be equal in status to suspects. The Israeli Supreme Court ruled that such act can be justified in the face of reliable incriminating evidence regarding the commission of the offense and on condition that the cover agents would not tempt innocent persons to commit crimes. The trick of using cover agents is based on the human need for contact with others. The assumption is that it is human nature that causes people in distress to seek discourse with others. Indeed, this ploy has been proven effective in many cases. It is claimed that taking advantage of the detention facility to operate an undercover agent is a legitimate investigative ploy that does not violate a suspect's privilege against self-incrimination. The privilege against self-incrimination does not prevent the police from trying to obtain the suspect's confession through indirect means. The need to provide warnings about the right to silence and the right to consult lawyers is intended to prevent the exploitation of the coercive atmosphere of the detention center to extract a confession. However, the confession to the cover agent is voluntary and does not violate the suspect's privilege against self-incrimination because the suspect do not have to share anything with the cover agents and they can avoid confessing to them. The underlying rationale of the warnings is to prevent government officials from using the coercive nature of confinement to extract confessions that the suspects would not give in an unrestrained environment. However, the element of coercion that exists in a typical interrogation setting is absent when the suspect talks to a cellmate. The warnings given to suspects by interrogators are intended to make it clear to the suspect that they should not fear from the interrogators if they do not confess or remain silent, or if they choose silence. They are necessary in a friendly conversation during which suspects pour out what is on their hearts and express their concern, not answers given to questions during an official interrogation. Ploys designed to lull suspects into a false sense of trust and security do not create a coercive atmosphere. From a practical point of view, undercover agents obviously cannot warn the suspects without such warnings running afoul of the possibility of using their services. And indeed, the Israeli Supreme Court held that such warnings are unnecessary because undercover agents are not persons of authority, whom the suspect should fear or hope for a benefit in exchange for a confession. Also, conversations with undercover agents cannot normally humiliate suspects or trample on their dignity. No pressure is exerted on the suspect. Therefore, the probative weight of a confession given to a person during a free conversation is seen as higher than that of a confession given during interrogations. Although the suspect did not choose to share their secrets with anyone on behalf of the police, they also did not choose to do so in a case of lawful wiretapping of their conversations with others. Undoubtedly, eavesdropping constitutes a severe intrusion into a person's privacy. It undermines a person's peace of mind and his freedom of will not to confess to his crimes to the police. However, as the Israeli Supreme Court noted, the law does not exclude confessions only because one is unaware of the practical consequences of the confession. In this sense, impairing suspect's ability to choose not to confess to the police is not a sufficient reason for denying the police access to reliable evidence. It is argued that a genuine commitment to the notion of free choice should lead to an unacceptable prohibition on gathering incriminating evidence in all circumstances where a person is unaware of the presence of the police. Every person who confesses to another takes on himself the risk that the listener will not keep the content of his conversations a secret. The prophet Micah in the Bible warned humankind generally to avoid trusting in others. Trust ye not in a friend, put ye not confidence in a familiar friend, keep the doors of thy mouth from her that lies in thy bosom. After all, even when a person tells his story to a real fellow detainee who is not an undercover agent, that fellow detainee could reveal his secret in exchange for mitigating his sentence. Obviously, given the motivation in the United States, also persons, detainees, and prisoners trade in information they overhear during random conversations, and they suggest their knowledge to the interrogators in exchange for some benefits. But it should be remembered that detention provides the police with control over the suspect's environment. A detainee does not choose his cellmates. He cannot leave and cannot ask them to leave the cell. A coercive atmosphere, although of a different nature, also exists when a detainee speaks with an undercover agent. The anxiety engendered by the custodial setting often leads the suspect to seek comfort and relief by talking to those around him. As said, it is human nature to seek affiliation and support, and persons need a sense of belonging, especially in times of distress. An investigative ruse that exploits the suspect's shaky emotional state to get him to confess to his crimes is both unfair and unreliable. Before expanding on the danger of reliability, I want to refer to the existing law regarding the legitimacy of using cover agents. The Israeli Supreme Court ruled that using undercover agents, including active cover agents, is a legitimate investigative ploy. However, the Israeli Supreme Court has placed limitations on the use of undercover agents. Generally, undercover agents are not allowed to violate the fundamental rights of suspects as well as the fairness of the criminal process. They are forbidden from resort to illegitimate methods of tricks or putting excessive pressure on suspects, which could lead to involuntary or unreliable confession. They must not try to convince the suspect to confess to a lesser offense, since even innocent persons can receive such advice due to the pressure of the detention and the fear of being convicted of a more severe offense. Undercover agents are not allowed to harm the relationship between the detainees and their defense lawyers, and the detainee's right to effective assistance of counsel. In this respect, the Israeli Supreme Court declared that the lawyer-client relationship is sacred. Undercover agents cannot incite detainees against their defense attorneys by blackening their names. Thus, the Supreme Court ruled that the undercover agents acted improperly and violated the right to remain silent and the right to consult the defense attorney when they incited the detainee against his defense attorney and falsely told him that his defense attorney was acting in a situation of a conflict of interest and that his advice to the suspect to remain silent is a bad advice and is intended only for the benefit of the counsel. And they advised him that he should make a statement to the interrogators without consulting his defense attorney. That would not help him anyway. In that case, the Supreme Court ruled the confession. Also, the undercover agents cannot convince detainees to give up representation by a lawyer, and they are not allowed to ask the detainees to give them information about their conversations with their defense attorneys. The district court in the Southern District excluded the confession of a defendant in a murder, which gave after the undercover agents sent him a false message from his defense attorney, according to which the defense attorney asked him to adjust his statement to his brother's statement, and after he will give statements, he will be released from custody. So the court overruled this confession. The district court in the Northern District overruled the minor's confession given to adult and full-bodied undercover agents, according to which he has murdered due to a mistake of identification. When the undercover agents approached the minor in a street in the city, and they told him that they knew that he murdered, that the disease was their friends. He caused them harm. He should pay for the harm a considerable sum of money, but they forgive him to some extent if we admit that he murdered by mistake. So finally, the minor admitted that he murdered by a mistake. So the court overruled this confession. In another case, the court approved the plea bargain made after the defendant was convicted of murder in the district court, according to which the conviction would be commuted to homicide and the sentence would be reduced from life imprisonment to 10 years in prison after the undercover agents violate the suspect's free will and exerted excessive pressure on him to admit, among other things, by warning him that if he consults a lawyer, his life as well as his family's life will be in danger, unless he takes responsibility for the offense attributed to him. It goes without saying that undercover agents are not allowed to resort to violence or threaten to resort to violence against the suspects, and certainly spitting on the suspect while blaming him for being a cover agent and showing a gesture of snapping his neck, as occurred in one of the cases, is unlawful behavior. Also, the Israeli Supreme Court prohibited undercover agents from using drugs with detainees in detention cells, as indeed occurred in one of the cases when the undercover brought drugs. In addition, giving undercover agent a financial incentive in exchange for extracting a confession may cause them to do everything in their power to do so. Similarly, the existence of any inducements, such as dismissing charges, mitigating the degree of punishment, and etc., may put the detainees in a situation of conflict of interest. In the past, the Israeli Supreme Court held that it is better to avoid agreements that put foreign interest for the undercover agents, such as financial compensation, and that if this cannot be avoided, the court will examine the reliability of the confession extracted through the undercover agents with caution. However, the Supreme Court in the Khaybatov case in 2018 held categorically that paying the undercover agents a special reward for extracting a confession is prohibited. Indeed, paying a salary to undercover agents in exchange for a confession significantly strengthens their interest in extracting confessions from the detainees. Also, the Supreme Court emphasized that it is not desirable to use the same undercover agents towards several people involved in the commission of a crime to avoid contaminating the statements of suspects by feeding them information. It held that the ideal situation is that the undercover agents would not know details about the circumstances of the crime attributed to the suspects. Despite these rulings, the essential concept, according to which the emphasis is placed not on the manner of employment of the undercover agents, but on the question of whether they actually violated the rights of the accused, still prevails. In Canada, in the past, emphasis was placed on the subjective belief of the suspects regarding their confession to a person of authority. Therefore, a confession to cover agents was seen as admissible despite the deception and the lack of warnings regarding the rights to remain silent and the right to consult defense attorneys. Today, there is a distinction between passive and active cover agents. An instructive conversation by active cover agents acting on behalf of the police is considered an interrogation. Parameters such as the nature of the conversation and especially whether it is a conversation that solicited an answer as well as the personal relationship the cover agents forged with the suspects affect the classification of the cover agents. However, there is no prohibition on the cover agents about talking with the detainees, and a question such as what happened is not considered an interrogation. Following Canada, Australian and New Zealand courts have also adopted the distinction between passive and active cover agents. The European Court of Human Rights also distinguished these two types of cover agents. It held that introducing a cover agent into the cell of the suspect who maintained the right to silence while giving instructions to the cover agent to extract a confession violates the fairness of the process and the privilege against self-incrimination. In the United States, the Supreme Court distinguished between passive and active cover agents regarding the violation of the accused person's right to be represented by a defense attorney established after the indictment against them has been filed. However, during the investigation phase, the use of active cover agents is allowed. A hazardous and sophisticated method of using active cover agents that originates in Canada is called Mr. Big. According to this method, described by the Supreme Court of Canada, the cover agents lures the suspect to participate in a fictitious criminal organization. He develops friendship with him over weeks and months in his natural surroundings. He shows him that working for the organization provides close friendships and financial gain. He emphasizes values of trust, honesty, and loyalty. He creates an atmosphere of violence by clarifying and sometimes by demonstrating the use of violence against the traitors in the organization. Belonging to an organization, however, exacts a price. The boss, Mr. Big, must confirm the suspect's membership in the organization. He demands honesty and interrogates the suspect about his past misdeeds, especially about the crime he is suspected of. Denial of guilt by the suspect of the offense attributed to him is rejected and taken as a lie. Mr. Biggs shows his disappointment and pressures the suspect to confess. As Mr. Biggs' interrogation continues, it is clear to the suspect that the prize awaiting for him is joining the organization and to participate in more serious crimes. When the suspect finally admits his guilt before Mr. Big, the fiction is exposed and the suspect is detained and put on trial. This technique is effective for extracting confessions, but this technique is dangerous in terms of due process and the pursuit of truth. An intensive interrogation accompanied by temptations and sometimes veiled threats increases the fear of false confessions. Such an investigation also creates a fear that the police will use unacceptable methods of tactics to extract confessions, such as resorting to violence against others in the presence of the suspect. In addition, the police, in this way, solicit people to commit offenses. For example, in one of the cases in Israel, the cover agent who impersonated as the head of a crime organization offered the suspect some jobs like burning cars, and they paid him a great amount of money for these offenses to make him want to be accepted as a member of the organization. Exposing the circumstances of the defendant's confession in court creates a biasing effect, as it shows their voluntary participation in committing crimes and their eagerness to join a criminal organization. Defendants testifying to the circumstances of their confession will have to tell the court that they lied to Mr. Big because their eagerness to join a crime organization was extremely high. And Mr. Big's scheme generates several concerns. The unreliability of the confessions given as part of it, bias against the accused, and the potential for illegal behavior by the police. Also, this ruse harms the autonomy of the accused by extracting pressures to admit guilt. The Supreme Court of Canada established a presumption that confessions made as part of a misrepresentation of a criminal organization are inadmissible. However, the prosecution can refute this presumption according to the balance of probabilities and show that the evidentiary value of the confession outweighs the prejudicial effect created by its acceptance. In addition, even a reliable confession will be excluded if it was obtained under coercion, for example, through physical violence. Against the recognition of the trick of using cover agents, it is argued that cover agents diminish suspects' freedom to remain silent and make an informed decision about giving information and opening their hearts to police agents. The sense of helplessness felt by custodial suspects or by suspects who are devoid of money and social relationships can lead them to trust a more experienced person who spreads protection over them. Although any actual detainee can turn the suspect in later, unlike a real detainee, an undercover agent is trained in psychological techniques that can get suspects to confess. When undercover agents are paid to extract a confession from the suspects, naturally their motivation to lie and to pressure the suspect to confess to the crime is high. It should be noted that in the places that attribute significance to this classification of the undercover agents as passive or active, receiving a salary in exchange for extracting a confession implies their classification as active. At any rate, undercover agents are often criminals that gain benefits in return for their work, like dismissing the charges against them. In one case, in Israel, that exemplifies the dangerous over-motivation of undercover agents, the undercover agents brought to the investigators a note containing incriminating evidence that was allegedly written in the suspect's handwriting. The forgery was discovered in court through graphological evidence. Although the motivation of undercover agents to provide the required evidence in order to gain benefits can damage their credibility in practice, the testimony of undercover agents is usually of great weight, both because undercover agents can be convincing liars and because they testify to the confession of the accused, which is seen as compelling evidence. However, it is argued that the fear of the reliability of confessions made to undercover agents cannot justify a blanket prohibition on receiving these confessions. Audio and visual documentation of the conversations between detainees and undercover agents diminishes and even overcomes the fear that the cover agents falsifies the very confession. Indeed, the Israeli Supreme Court ruled that the police must ensure continuous and complete documentation of all interaction between the suspects and the undercover agents to supervise the activities of the undercover agents. The police must even record the conversations between the undercover agents and the detainees. Although it is possible to rely on unrecorded statements in exceptional cases, indeed, in some cases, the court was willing to rely on the undercover agent's testimony regarding the defendant's confession, which was not reflected in the recording. It was ruled that when the confession is not recorded, for example, due to difficulties in hearing and understanding the exchange of words, the undercover agent's testimony about the detainee's confession must be treated with extreme caution. Still, there is no obstacle to relying on such testimony. I think that at least the court should have required a strong corroboration to the testimony of the cover agents regarding the detainee's confession. At any rate, it is essential to visually document the entirety of the conversations between undercover agents and detainees. Audio recording alone does not provide a good account of the relationship between the undercover agents and the suspects. It does not allow, for example, to present as evidence to the court, as could have been done in the case of Khaybatov, the use of hard drugs by the undercover agent and the suspect during the conversations with them. But in principle, using active cover agents is problematic and should be forbidden. This is because the chance that active undercover agents will extract false confessions is much higher than the chance that passive undercover agents will cause such a result. In contrast to an actual detainee, an undercover agent is trained in psychological techniques that could manipulate the suspect into confessing. Such methods could, for example, lead the suspect to invent a criminal record to meet his cellmate expectations and upgrade his status. In an environment surrounded by actual or potential violence, detainees can fabricate a criminal record to portray themselves as harsh. Thus, for example, in the case of Perkins in the United States, the undercover used the suspect's desire to escape from prison and his fear of being ostracized if he changed the murder story he had previously told his cellmate to extract his confession. In the Israeli case of Khaybatov, when the undercover agent presented himself as the head of a criminal organization, his defense attorney described that things got to the point when the undercover agent gave Khaybatov, the suspect, a swearing-in ceremony in which he accepted him as a soldier in the crime family of which he had. In another case of Suleiman El-Abid, the undercover agent told him that he would take the blame for the murder and take care of his escape to Egypt if he revealed to him the location of the body. Suleiman El-Abid did confess to the undercover agent about the murder and about the location of the body, but the body was found later in a very different place. The contradiction between the details of the confession and the crime details has not prevented El-Abid's conviction, which many scholars considered as a wrongful conviction. Active undercover agents may falsely clarify to suspects that their evidentiary situation is hopeless and consequently bring them to despair and the desire to give a statement that will improve their evidentiary situation, such as admitting to causing death in a state of intoxication or self-defense. In addition, undercover agents can help suspects formulate their version of events and make them understand and pleading guilty and make them understand that this will result in their release from custody or in charging them with a lighter offense. Typically, cover agents are not allowed to give suspects legal advice, but that often happens. The Israeli case of Mar Kuznetsov, in which the undercover agents advised the suspect to confess, is an example of the pressure that active undercover agents exert on the suspect while giving erroneous legal bits of advice. To the undercover agent's question, if he witnessed the suspect, if he witnessed the murder of the deceased, and so what happened, the suspect replied, "I saw police photos." During the conversations, the undercover agents advised the defendant, the suspect, to examine the possibility that he had argued with the deceased earlier, and because of that, he stabbed him, while one of the cover agents even pointed out, if you were drunk, it does not count, it's not murder, 5 to 6 years. And the second cover agent added, what 5 to 6 years, 20 months, what you are talking about? Also, one of the undercover agents solicited the accused to cooperate with the interrogator, stating that if you continue like this, pretending that you don't remember and don't understand, you will get 30 years. In another case, the undercover agents demanded answers from a minor custodial suspect. One of the undercover agents demanded that it would answer the questions of another undercover agent regarding the offense attributed to him by saying, "You will speak like a man and you will speak. Whatever he asks you, you will answer." Thus, when undercover agents actually interrogate the suspect has no moment of being alone to calmly estimate the incriminating evidence against him, consider how to face the interrogation, and plan a strategy of resistance. So, in my view, active cover agents should not be allowed. But even the distinction between passive and active undercover agents is not simple. The line between passivity and activity, regarding whether certain statements express sole listening or direct the detainee to a specific answer, can be tiny and subject to interpretations. Given people's psychological need to talk, which is intensified due to the isolation from the natural environment following the detention, even a supposedly neutral statement such as what happens invite suspects to speak about the crime attributed to them. Some propose, therefore, to adopt an objective and straightforward test that focuses on the question of whether the undercover agents planted in the cell by the police to gain information from a specific accused, or whether it is the coincidental presence of an actual detainee who volunteered to tell the police investigators about the information given to him by his cellmate. Those scholars suggest totally banning the use of cover agents. At any rate, it should be noted that even a passive undercover agent may extract false confessions if he presents a threatening cover story, according to which he is a tough felon or even head of a criminal organization. Such a false story may lead detainees to fabricate a criminal record to win the patronage of these undercover agents. Indeed, innocent suspects who find themselves in front of a person who presents himself as a harsh criminal can confess to him out of bragging that aims to pretend him as a harsh criminal, out of fear of him, and out of the desire to be left alone. To prevent false confessions, even a passive cover agent should not represent himself as experienced or tough criminal. Besides reliability concerns, undercover agents violate trust, friendship, and intimacy values. The impersonation of undercover agents as friends generates a feeling of betrayal, damaging trust between people. Thus, for example, in Canada, An accused called one of his members in the organization upon his arrest, whom he considered his closest person. After his arrest and after realizing that his best friend had been deceiving him, he developed paranoia, refused to trust his defense attorney and even his wife, and was finally hospitalized in a psychiatric hospital. The pretense of friendship implies treating a person as a means and not as an independent end, and the discovery of a fraud can lead to a suspicious attitude toward all friendships in the future. Some underestimate the weight of this argument and hold that the loss of a sense of trust does not justify disqualifying the use of a means that has the power to extract reliable confessions. Detainees are aware of the possibility of planting undercover agents in the cell, and protecting suspects from their own stupidity is not a sufficient justification for rejecting reliable evidence. A person who did not give an incriminating confession would have no idea that his cellmate was not a real friend. Regarding suspects who are aware of it, it is argued that such a breach of trust is no more humiliating than their mere interrogation and detention. At any rate, in terms of due process, undercover agents often shape the narrative of the suspects while creating a virtual reality. Shaping reality can be done by giving bad advice, such as when the undercover agent advises the suspect to confess because his investigators want his best interest, misleads him about the results of his confession, or falsely states that in Israel investigators are not allowed to lie about the existence of incriminating evidence, as the undercover told Zadorov, who was suspected of murder. Zadorov's interrogators lied to him that the victim's blood was found on his knife. The Israeli Supreme Court allows such a lie. Zadorov asked the cover agent whether the interrogators were permitted to lie, and the cover agents misled him that it was impossible in Israel. And Zadorov is immigrant from Russia, and he really didn't know it. Similarly, when the undercover agent falsely presents himself as the head of a criminal organization or pretends to be experienced in the criminal world, he creates a fake reality. He implicitly invites his cellmate to show proof of his criminal credentials so that he would consider him a professional and experienced criminal worthy of appreciation and treat him as an equal. Creating a fake reality which extracts pressure on the suspect to refer to it violates the burden of proof imposed on the prosecution by causing the suspect to refer to false evidence presented to them instead of trying to refute the actual evidence or avoid providing a statement. In the adversarial system, bearing the obligation to prove the accusations, the prosecution is first to present its evidence, allowing the defendant to address and refute it. Indeed, at the interrogation phase, no duty is imposed on the interrogators to disclose the incriminating evidence at their disposal to suspects. But when undercover agents pose as fellow detainees, let alone when they present false evidence or give misleading advice, they force suspects to shape their defense in the face of false information. In turn, this harms the suspect's ability to make informed decisions and respond coherently to the accusations leveled against them. It assumes the suspect's guilt and creates a false impression that silence is futile. The continued use of techniques that alter suspects' perception of reality and mislead them regarding the case against them cast doubt on the accuracy of the confession. After all, if you have an experienced criminal as your friend who tells you that the victim's blood was found on your knife, you must try to explain its existence. Silence would not help, so there is a substantial possibility that you will lie, trying to explain evidence that does not exist, or falsely confess to gain some benefit. So thank you very much for your